2 states, 2 defendants, and 0 ounces of common sense. Buckle up, because today's courtroom chaos hits hard from the jump. Let me know in the comments which state takes the crown for Sovereign Citizen of the Week.
You're not prepared this morning with your sovereign citizen argument? You needed some additional time to prepare?
Yes, sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come back?
Next matter is State of Kansas versus Gordon Cooley. Case number is 24TR65. Are you Gordon Cooley? You'll need to unmute your screen, sir.
Yes, I am the man that is that person.
All right, so you're Gordon Cooley?
Yep.
Very well. State appears by Jill Gillette, County Attorney. Mr. Cooley, there's been an amended complaint filed on, it looks like April 17th. You're charged with driving while suspended as a second offense for on or about March the 25th of 2024 in Elk County, Kansas. If indeed you have a prior conviction where this would be a second offense, that's a Class A misdemeanor. A Class A misdemeanor is punishable up to 1 year in the county jail and a fine not to exceed $2,500. Additionally, with a second offense for driving while suspended, there's a mandatory 5-day minimum sentence. However, a person can be placed on probation from that, but there is mandatory sentence that would have to be imposed. Do you understand what you're charged with?
No, I don't quite understand those no, I don't.
Quick legal note, a second offense driving while suspended charge is no joke. Judges don't care about your "I'm a free man traveling the land" speech. The law sees you drove with no license. End of story.
Your question in regards to what you're charged with.
Well, I think this is a matter of a mistaken identity. My persons was never involved in anything. I'm carrying my property from point A to point B. There's no vested interest of the state to even stop me. I'm exercising my God-given constitutionally protected rights, and I stated that to the man acting as the police officer. I didn't present him with a
You
license.
are charged, sir. Hold on. You're charged with driving while suspended, a second offense. That would indicate to me that you've had a first offense.
No,
Have you been in court before on this type of charge?
nope, not on driving while suspended. No, I have not.
All right. Well, that is what you're charged with. You don't have to agree with it. You can, certainly that is an issue at trial if you feel you have a defense. As with the others that I've explained, you have certain rights. You are charged with a misdemeanor, so you are entitled to be represented by a counsel. And if you wish to apply for court-appointed counsel, if you meet the financial guidelines, I would appoint one to represent you. You also have the right to represent yourself. You also have the right to have counsel of your own choosing at your own expense. So at this time, if you wish to have a trial, if you wish to speak with an attorney or counsel, would he qualify under any programs you have since you charged this as a second offense?
No.
All right. So apparently diversion wouldn't be an option for you. So if you're wishing to have a trial or to speak with an attorney, your plea at this time should be not guilty. If you wish to plead guilty, then we'd proceed to sentencing. But based upon what you're telling me, those would be issues that could be addressed at trial. So at this time, how do you wish to plead?
I don't plan to plea. I guess I'll answer in the formative that Demers is not acquiesced quasi-jury.
Right. If you're not going to enter a formal plea, you're standing mute, and I will enter a plea of not guilty on your behalf.
Okay, I exercise my right to trial by jury then. I'd like to face the man or the woman that claims I've done them harm or loss.
Mr. Cooley, if you wish to have a trial by jury.
I'm Gordy. I'm not Mr. Cooley. I'm Gordy. I'm a man. I'm not a person.
All right. Mr. Cooley.
Can I ask you a question?
You need to be quiet for a moment. I'm going to explain what the situation is. You have the right to be represented by counsel. entered a plea, refusing to enter a plea, which is fine. A person can stand mute, and I will set this matter for trial. If you wish to be or have a jury trial, you have the right to do so. However, you need to do that in the proper form. With a misdemeanor offense, you have to file a written motion for that request. Otherwise, it's set before the court. So you would need to do that in a timely way. If you're going to represent yourself, you would have to follow the rules as though you're an attorney. So all of those things would, most people don't have the training to where if they're going to do a jury trial, they're better off being represented by counsel. But that's a choice that you're going to have to make.
Okay, can I ask you a question?
Yes, you may.
Can there be a valid cause of action without an injured party?
Sir, that's not a valid question for what we're doing here today.
I've tried settling this matter in the private twice. If you have any papers in front of you with my signature on them, it's because that is what was required for me to get away from my cap.
Chat, be honest, why do sovereign citizens always act shocked when the judge reads the charges? Like, sir, you were suspended last time too. Did the universe suspend you unfairly as well?
I don't understand what a man thinks that he has the authority to take another man and throw them in a box when they have harmed no man or woman, no
Mr.
claim
Cooley,
has been brought
Mr.
against
Cooley,
them.
you need to be quiet now. We're going to give you a court date, and you can advise me how you're going to proceed at that court date. If you're going to apply for a jury trial, then you'll need to make that application by that time. Otherwise, you'll be set for a bench trial. That's before the court. Sarah, could you give us a date, please?
What sort of time frame would you like, Judge? 30 minutes?
Approximately 30 days, 30 minutes would be fine.
We can do May 15th at 2:30.
Judge, I'm out that afternoon. We could do 11:30 if there's nothing else scheduled there.
We put that for a trial for an hour, didn't we? So
We could, if you only need 30 minutes, we could do the 11 to 12.
well, we said something at 10:30, I believe, or was it the 10 o'clock that was set for trial?
It was the 10:30 to 11:30 that was set.
Okay, let's set this at 11:30 for a pretrial. So, Mr. Cooley, you will need to appear at the courthouse in Howard. And if you're going to file a motion for a jury trial, you need to have done so by that time. If you're going to hire an attorney, you need to do that. If you're going to apply for an attorney, I would suggest that you do that as soon as possible, so that you can have counsel at that time.
Am I going to be able to face the man or the woman that has a claim before me, or are you going to discharge the matter? If there's not a man or a woman here, then this matter needs to be discharged.
Sir, I've heard these arguments before, and those are not legal arguments. Somebody's made these things.
I'm not a member of the legal society.
Sir,
Can we bring the law to the court, please? Can we bring the law to the court?
Mr. Cooley, stop interrupting. At your hearing, if you have motions that you wish to have heard, you can file them in advance. I would strongly recommend you be represented by counsel. But your court appearance is May 15th at 11:30, and you are to be here in person.
I will invoke my common law rights.
Standing mute is a real legal option, but it doesn't do what sovereign citizens think it does. All it means is the judge enters not guilty for you and keeps the train moving. No magic loopholes unlocked.
I'll come to the jail and talk to you.
Good morning.
Good morning, sir.
How you doing this morning?
I'm well. How are you?
Morris had previously, it was one case that I was already representing him on. I don't know that we ever got one on this most recent charge. Okay.
Let me see.
Mr. Morris, I know Mr. Hill was representing you in the 23174 case. You're here for an arraignment on the 24 CF49 case. Has your financial circumstances changed?
No, sir.
All right, I'm going to appoint the law officer here, Mark Sims, to represent you in the 24 case.
I go state this to the own.
Raise your right hand and
Yes.
Now that Mr. Hill is representing you, probably want to talk to Mr. Hill before you say anything. We're recording this proceeding, so anything you say may be used against you. But I'm listening to whatever you want me to consider.
I'm not real sure what Mr. Morris is trying to claim in that writing right there. Said he's not a citizen and something about a secure.
My name is Alizé Morris, a secure party creditor under the UCC 1 filed in Florida. American national being held in custody in Gulf County, which is not a 14th Amendment citizen of the United States. Not a record. So documentation, which is official records. So stated, I'm the agent of the said person.
Who wrote that for you?
I did.
Why do you need to read it if you know what you're talking about?
This memory.
Okay. Tell me what the 14th Amendment says.
That you were considered a slave under the 14th Amendment.
That who's considered a slave? I'm not a slave.
No, the incarcerated person. If you commit a crime.
Okay. Doesn't say if you commit a crime.
Or yeah.
That's not what it reads.
I got the 14th Amendment really wasn't in the book.
What book?
The book that we had in the back.
What book do you have in the back?
It's a law book.
What law book is it?
Florida statute book. Yes.
So the 14th Amendment isn't in the Florida statutes? That's because it's an amendment to the U.S. Constitution.
Mm-hmm.
So you don't know what the 14th Amendment reads?
The 14th Amendment reads not off on the top. Not off.
Okay.
Kansas was funny, but Florida is about to unlock a whole new difficulty level of courtroom delusion. Watch how Judge Collier handles this with Jedi-level patience.
That I'm a secure party creditor on the UCC 1.
Tell me what the UCC 1 reads.
I wish I had my documentation in front of me to present it all the way. I wish I had someone here that was supposed to be here so I can have it.
I asked you who wrote that for you. You said you did.
I wrote it. Yes.
So do you know what you're talking about?
Yes, sir.
All right, so tell me what the UCC 1 reads.
It's the Uniform Commercial Code filed with the Secretary of State or within the entities under the contract with the Secretary of the State to maintain uniform commercial code records and database of judgment liens maintained by the Secretary of State.
Now tell me what UCC 1 reads.
It's a statement and it's financial.
You don't know what the UCC 1 reads, do you?
Not on top.
You're not prepared. You're not prepared this morning with your sovereign citizen argument. You needed some additional time to prepare.
Yes, sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come?
I would ask that he's got 2 cases. I know one we've got already got the discovery on that I need to go meet with him at the jail and go over. Being at the jail, I can find time between now and May 9th to go to the jail and take care of that.
All right, Mr. Morrison, you come back. Usually when sovereign citizens come in the courtroom, at least they can recite from memory a lot of the stuff they travel under. So next time you want to come with your sovereign citizen argument, be prepared, okay? I'll listen to you, but be prepared.
Yes.
But you're not doing justice to your fellow traveling nationals who consider themselves sovereign citizens if you're not prepared to even articulate what the argument is, all right?
Yes, sir.
All right, we'll see you May 9th at 1:30.
Today.
Be prepared next time, all right?
Yes, sir.
They should have a constitution in the back so you can read the 14th Amendment and be able to tell me what it reads. And
what it says right here. What is state?
We're gonna May 9th at 1:30.
Machine into a contract.
That's not a contract. That's giving you notice that you're
Yes,
gonna come back.
Leadership.
You're fine. I'm not going to query you about what a contract is, but we'll talk about whatever you want me to consider next time.
Is Braden Sandell, 2300418SM.
Andrea McCray appearing on behalf of the people.
Patrick O'Keefe on behalf of Mr. Sandell.
And you, sir, you're Braden Sandell. And keep your voice up so we can record you.
Yes, ma'am.
Today is the date for sentencing. We had a trial in this matter where the defendant was found guilty. We have a pre-sentence report with recommendations. Mr. O'Keefe, you've been able to go over that with the client?
Yes, I have, Your Honor.
Additions, deletions, corrections to the factual content?
We have none, Your Honor.
Ms. McCrae, you did enter your appearance today. Do the people have anything for sentencing?
No, I mean, I'll just note for the record that victim in this matter, Ms. Boss, did not want to be here today. She thought there was going to be, her words were, a lot of tension in the courtroom. But I've had good contact with her. She was happy with the outcome. Awesome.
Mr. O'Keefe.
Your Honor, we filed a petition to defer the conviction under MCL 769.4A. It's my understanding that the people are objecting to that. So I would just ask that the court grant that petition.
I don't think I have authority to over an objection. I think the statute specifically gives the discretion to the prosecution.
That was my understanding, Your Honor, of the statute. And to be clear, I am objecting.
Consent of the accused and of the prosecuting attorney in consultation with the victim. So it requires consent from the prosecutor.
I see. Okay, Your Honor. Well, given that they're objecting, I think the court's correct. It would not be able to defer the conviction under that, so I'll withdraw the petition.
Sure.
I suppose I'll keep the petition on the table, but given that they're objecting, I'm not going to ask the court grant the petition. Aside from this, Your Honor, the court heard all the testimony in this matter. I know the court has had a chance to review the pre-sentence report. I think the pre-sentence report is accurate. I think the recommendations made in the pre-sentence report are appropriate. I would simply ask that the court enter an order adopting all the recommendations in the report. Thank you, Your Honor.
Mr. Sandell, what would you like to say to do for our sentencing?
Mr. Sandell is very nervous and he's indicated he does not wish to address the court at sentencing today. Thank you.
Okay. Brings to mind, the pre-sentence questionnaire, wherein he could provide his circumstances of this. He could have said, I had a trial, I maintain my innocence, I don't want to talk about it. This is what he writes instead. I dated a very shitty person who lied her way into getting me in trouble. That is what Mr. Sandell thought was the appropriate response to a court pre-sentence questionnaire after a conviction. I did hear the testimony and evidence in this case and observed the demeanor of the defendant during the trial, as well as observing his choice in the questionnaire. The reason why they tell you sometimes remaining silent is better, because this is offensive. This is victim blaming. I don't care for it. I think that you are a very arrogant young man, and unless you begin to have some, introspection about your own role in your behavior, nothing's going to change. Mr. O'Keefe, has your client started a VIP program already, or he would be starting something new at this point?
The batter's intervention program? I don't believe he started that yet.
Okay.
Is that correct?
It just affects the length of the probation because it can take a whole year to complete. Assault that was described during the trial was pretty significant. Continuing assault. Sentence of the court will include probation and jail. Probation term will be ordered to be 12 months. As I said, it can take you 12 months to finish the class, and therefore I have to give you 12 months probation to give you enough time to complete that class It's really 6 to 12 months, but it sort of depends on your assessment and your participation in the class. So you can choose to go to the class and insist that you have no wrongdoing and you're not there to learn anything, and you'll probably be there longer. Or you could choose to go in and decide that you wouldn't be in court if you didn't have something to learn, and try to learn something from the class and complete it. During probation, meet with your probation officer as directed. Do not leave the state without permission. Do not commit any crimes. You're not to have contact with Sydney Voss without permission from the court. You're not to engage in assaultive or threatening behaviors. You're not to use alcohol, marijuana, or controlled substances without a prescription. You are to submit to random testing to prove that you're remaining sober under court order. You're not to attend bars or nightclubs during the probationary term. Does your employment take you into bars or nightclubs? It's not very specific. It just says union labor, so it doesn't really tell me exactly what you do.
He builds bridges,
Okay.
construction.
I do remember that from the trial. Yep. You are to complete the domestic violence batteries intervention program. Further, I've ordered if you test positive for some substances, you'll complete a substance abuse assessment and follow those recommendations. You're to maintain employment. You're not to purchase or possess firearms during probation. The probation oversight fees are $30 per month for 12 months. That's $360. There's a $50 state minimum cost. There's a $75 crime victim rights fee. There's a $250 fine for a total of $735. You will begin your probation by serving 6 days in jail with credit for the 2 that you've already served. If you'd like to appeal my sentence and you need a public defender to assist with your appeal, you need to make your application within 14 days. Questions about your sentence, sir? Mr. O'Keefe?
Would the court give him the opportunity to report on Friday night? Which, given that I expect he's probably scheduled to work in these next couple of days. I don't know what his work schedule is off top. We haven't discussed that, but I just want to make sure that he's able to keep his job and make arrangements to take the time off to serve the time.
Okay, beginning Friday, June 30th at 7 p.m. Just remember that I don't delay sentence very often, so since you got a delayed sentence once, I won't delay it again. Don't violate your probation.
Sure. Thank you.
Thank you. Versus Jermaine Newell, 2202651FY.
Andrea McCray appearing on behalf of the people.
And you are Jermaine Newell.
Yes.
Today is the date for defendant's motion for early discharge. So just to sort of recap, Mr. Newell was allowed to plead to operating intoxicated second offense and possession of a firearm while intoxicated back in November. In January, he was given 9 months of probation. So would that take us out to like October-ish would be your end date? Does that sound right? Okay. October-ish. I do have an email. Oh yeah, here they wrote the end date, I think, on here. Maybe. No, that's not the end date. Mr. Hanna did send me an email, so I'll read that for the benefit of both prosecution and defense. It says, Mr. Newell completed treatment at Cristo Rey, is continuing treatment on his own. He attends 12-step meetings most days and has all of his fines and costs paid. He has been a model probationer that has completed all of his required programming. He has had no violations since his sentence January 9th. Ms. McCray, on your objection.
Yes, thank you, Your Honor. So while I'm very happy to hear that he's doing so well, that really is all very good to hear all of that. I know that trying to maintain sobriety is a daily challenge, and so I certainly commend him for that. So I hope that maybe he won't take personal offense to my objection. But this is a second OWI. It was done in November, so this was done prior to me as being the prosecutor, but I think, well, I won't go into that. But there's also a gun in the car. So for those reasons, Judge, I'm going to have to object on this one. Though I think he's probably the best case of people that are successful from the OWIs that have come before us. Just because there was a gun in the car and it was second, I'm going to have to maintain my objection.
Okay. I just want to note for the record, the prior was December of 2017, so it hasn't been 10 years since your prior. it has been, at the time of this event, only like 5 years. So, Mr. Newell, I guess tell me why I should feel like it's safe to let you off probation early.
Okay, it's mostly because, like the last time I was here, you told me about the whole, it's mostly grief and the death of my family. That's why I was doing it. Like my wife passed in 2016, so 17, we were doing this, doing that. And I had a couple of drinks and then I drove when I shouldn't have. And then the second one, like I said, like I lost my mom, sister, and my brother. My brother was killed in October of 2020. And then my mother died in 2019 in November, and my sister died in June 2000. So there's a lot of death. But when you told me the last time when I was here, it was mostly like, it's always be death. So you got to find out a different way to do it. So that's why I'm still attending Crystal Ray, trying to, doing the Greek thing. So that's why we're doing that. And I accomplished that as far as saying what I needed to do. And I figured out in my own mind what I needed to do. So that's why I take the one step at a time, like I say, 24 hours of sobriety. And as far as the gun charge, like I guess me growing up, I always had a gun, you know what I'm saying? I'm licensed to carry a gun, you know what I'm saying? Like for protection wise on, you know, cases or whatever, because I just got robbed not too long ago or whatever.
Did they take your concealed pistol license because you got OWI? Yeah, I thought so. They won't let you carry when you get these drunk driving charges. I think at the first one they take it for like a year, and then now that you have the second one, I don't know. Are they ever going to get that back to you?
Yeah, I'm not worried about it anymore. Yeah.
It's a little concerning to me that you said you grew up always carrying a gun. Because
No,
I feel like,
not like carrying guns. Like I was born and raised in Alabama, so
yeah.
we did a hunt. And
I just feel like that's the problem today. I guess I'm a little sensitive to it. Like 2 weeks ago, I was hearing a case where a 13-year-old, a 17-year-old, an 18-year-old all showed up with a gun. Why does everyone got to have a gun?
Yeah, no.
And you know how that turned out? Everyone started shooting.
Was it like, oh, my bad, I'm sorry.
Oh, no, go ahead.
It was like, I never had, I haven't used, I never thought of using a gun as far as like trying to kill somebody or rob somebody. You know, I always worked for my own and took care of my own self. You know, I'll be 50 next year, so like, not 12, you know, so I don't consider it to be like a weapon of defense or whatever. Just more along the line.
You had it when you were drunk, and you can't do that.
Yeah, well, I had it. I thought it was in the trunk because I wasn't drunk when I went to the, you know, I went to the bar, and that's why I had it. It was on the, just laying on the back seat or whatever. That's why I told her that. And I thought I put it in the trunk.
Yeah.
But
That's super unsafe too, you know, because people keep stealing guns. So, you know, they would have seen it on your seat. They would have just like broke your window to the gun. Yeah. Okay. Well, I understand the prosecution's objection, but Mr. Newell, you have a plan in place if you're feeling like, one, if somebody passes and you're feeling that way again, or two, if you're feeling like drinking, you have a plan?
Yes, I don't even drink anymore. I got my 8 months now.
Do you have a sponsor?
Yes, I have a sponsor. I'm trying to see what the letter.
Okay. Are your sponsor wrote a letter for you?
Yeah.
Can I see it? Well, yeah, of course. For the court. Sure.
And then,
Just interested. If you took the time to write it, we should look at it.
Right.
Your counselor, you mean?
Yes, counsel.
The record, I'm in possession of 3 letters written on behalf of Mr. Newell, which speaks very kindly of him and his progress.
I just had an uncle that passed that was like my father figure down south, whatever. My probation officer ready to go, and then when I was down there, you know, I didn't think about the whole drinking thing. You know, along the line of like, just wanted to be there for him. And then my son, he just graduated from college from Kansas State for aerospace engineering, and I wasn't able to attend it, so it was kind of like hard, you know, because I couldn't leave out the state.
Yeah, I mean, whether I let you off probation today or I let you off in November, there comes a time where you're no longer accountable to me and you have to make choices because you're accountable to the community in a way, right? If you get a third one, you're talking a felony charge, you're talking potential prison, you're talking lives at risk. So.
And this right here is why sovereign citizen scripts never hold up. The judges actually know the law. Imagine walking into court with Google knowledge and getting fact-checked by a man with 20 years on the bench.